Hey, what's going on, my brothers and sisters? Greetings. This is Greg Ward with the Common Law Rights Society. I just want to continue on our research and our discussion on private express trusts and our discussion with the Carlton Weiss uh, method of the private express trust administration. I want to um, give you guys a little insight, a little look at this article by Carlton Weiss called Trustees in Commerce, A Way of Life. And I think you guys, if you haven't seen this before, you're going to be pretty amazed and you're going to love what Carlton has to say about the private express trusts. So we're going to continue our discussion and continue to make videos to read to you guys the Concise Trustee Handbook by Carlton Weiss. But in the meantime, I want to give you guys this article to digest, and I think you're going to really love it. So let's go ahead and take a look. All right. Let's take a look, you guys. All right, so Carlton Weiss, Trustees in Commerce, A Way of Life. Here we go. It says, a while back, I was asked to write a few paragraphs on the specific advantages of living your life as a trustee in everything you do, as opposed to as a sovereign or secured party. I was asked to cover all related bases. That included a comparison to show how each choice would hold up in commerce. What I came to realize is that there is only one way of life in its own category that enhances all others. All the others are actually disadvantages in commerce. So you guys, let me read that again. He said, what I came to realize is that there is only one way of life in its own category that enhances all others. All the others are actually disadvantages in commerce. Let's continue. At the time, I had just developed a surefire way of piercing pure trust, and I was on my way to finally uncovering the pivotal flaw in federal contract trusts. What my clients were asking from me at the time was a technology that would allow a statutory entity like an LLC to sniff out minimum contacts people had that bound them to legislative jurisdiction, which would obviously allow the client to overcome the burden of establishing jurisdiction in their lawsuits against those people. I had no guilt about this because my philosophy is that ignorance is never an excuse. Equity compels performance regardless. All right, so a little background on Carlton Weiss. Carlton's job was to pierce these trusts, to pierce these asset protection programs that people had set up. And so he was being hired to go ahead and look at these different entities and these different ways that people were protecting their assets. And in doing so, he discovered that the private express trust is the only way to go. Let's continue. Excuse me. He says, I only assisted with cases that involved people claiming to be sovereigns, secured parties, general managers, managing directors, and other players in entities like pure trusts, federal contract trusts, and corporations sole. In each instance, there was always a common theme: contradiction. Every single one of the people I cracked had contradicted themselves by their stated position compared to their actual position. Every single one of the non-statutory entities I helped pierce was a contradiction by its intended nature and its actual nature. Sovereigns were nothing more than cestui trusts, beneficiaries. Secured parties were nothing more than people with split personalities reflected in a commercial recording. Even though I understood where they went wrong, the way they went about it was so rife with contradictions, you got the sense they had a screw loose. They couldn't really be helped because they wanted to be respected as creditors when it suited their needs. Yet they wanted to be absolved of liability like wards of the court when the pressure was too much. Likewise, pure trusts were really nothing more than unincorporated associations calling themselves trusts. And most Federal contract trusts were nothing more than partnerships wishing they had the protection of the federal courts under Article 1, Section 10 of the federal Constitution. They were contracts indeed, but they contradicted the original intent of the constitutional clause they sought protection under because the participants were exercising a franchise either during the formation or the life of the trust. These strategies I was seeing and continue to see place all the eggs in one basket. The really sad thing is the basket was made to hold bread, so the eggs never made it to the market whole. All right, so he goes on and talks about sovereignty. He says, sovereignty, mission impossible. The sovereigns, quote unquote, I studied with during my research initially had a good point and good case law to back up the point. However, as I sicked my investigative dogs on the case, I peeled back one layer after another of confusion. I saw the truth about the strict confines of any sovereign's role in the nation or kingdom of which he is the head. I was somewhat transplanted into the mind of the judges who had decided the cases most quote-unquote sovereigns rely on today. It became apparent that the case law actually shot sovereigns in the foot by holding over their head an internationally recognized standard they couldn't practically live up to with their limited financial and natural resources in today's commercial arena. In the end, I didn't even need to cite legal authorities to prove this to them, though articles like George Mercier's Invisible Contracts, Richard Landseal's Benefits Accepted equals Jurisdiction, James Montgomery's The United States is Still a British Colony, The Informer's Fallacy and Myth of the People Being the Sovereign, and timeless classics like William Whiting's War Powers certainly hit home. The problem most of them face is that they invested a lot of time and funds into something that turns out to be false. They thought they held sovereignty, but they could now see that they voluntarily contracted themselves under suzerainty at best. I'm not sure if I pronounced that right. To be truly sovereign in olden times, you needed nothing less than 1, a plot of land that you have absolute dominion over. 2, a fortified castle strategically placed on the land so as to protect you, the sovereign. 3, a military to protect the castle and land. 4, workers to do maintenance on the castle and the land. 5, a stockpile of weapons high-powered enough to wipe out any threat inside or outside your castle and plot of land. 6, a stockpile of gold and silver or material or natural resources to pay the militia, workers, and sustain the economy that develops out of daily needs people have when living in self-sustaining communities. This includes a stockpile of financial or natural resources to build up your reserves for tough times. And to top it all off, 7, a full sense of how to negotiate with other people who are in the same position as you, sovereigns, especially those who have bigger weapons than yours and might want to take your castle by force or fraud to consolidate their own empire. Today, not much has changed except for what electronic technology has made possible. To be truly sovereign nowadays, you need nothing less than 1, a plot of land that you have absolute title to, even stronger than the protections granted under the castle doctrine in Texas. It has to be a title so strong that it is recognized all over the world, not just in one state or country, because real sovereignty is an international quality. 2, a fortified compound. 3, a militia to protect the compound and the land. It has to be more than just guard dogs. It must be an actual military presence that sends a clear message to all within earshot of your land not to invade, much less trespass. 4, workers to maintain the compound and land. 5, a stockpile of weapons or technology powerful enough to stop a modern military offensive against you. 6, a stockpile of coin, gold, and silver to keep you from having to use Federal Reserve notes or ameros. You need sufficient natural resources to live on and pay your people with, so as not to have to engage in commerce as a sovereign. Otherwise, you reduce yourself to the status of a merchant and your sovereignty is lost. And to top it all off, 6, a full understanding of trust law as it pertains to sovereigns as trustees and merchants as beneficiaries. contract law, national security law, and negotiable instruments law, as well as the laws of power relating to sovereigns and other heads of state so that you can negotiate with the United States and state governments in a way that doesn't get you dead, conquered, or imprisoned because those sovereigns had more powerful weapons than yours. Otherwise, you'll end up like the Native American nations, many of which gave up their sovereignty to engage in commerce via gambling halls and casinos. The problems you immediately face are all issues of practicality, such as one, while you can remove land from the unincorporated city or county, your title is not absolute. You cannot effectively exercise absolute title to land as an individual, at least not land that isn't in the middle of nowhere. This kind of isolation leaves you at risk of invasion and limits your flexibility in the information age. Excuse me. In isolation, you have no eyes and ears out in the rest of the world to stay ahead of other sovereigns looking to expand or consolidate their empire. Eyes and ears are what gives you intelligence to avoid being checkmated. 2. A compound is very expensive to build and difficult to maintain. Independent power, utilities, and services need to be installed off the grid. For internet access, you would need to build your own satellite, maintain your own servers, etc. Regardless, however, if the fork goes, so do you, because the eggs are all in one basket. 3. Having a private military is a direct threat to the United States and state governments who are far too corrupted to appreciate the absolute right of self-defense, much less the right to bear arms on an individual or nationalistic level. 4. A stockpile of weapons will attract some unwanted attention. It will deter other sovereign men. But sovereigns like the United States who stockpile tanks and missiles might not deter so easily. Though stockpiling weapons can be done with prudence, especially with some ingenuity, the more firearms you have, the more suspicious other sovereigns will be of your motives behind stockpiling. An arms race then ensues, and you face the likelihood of invasion or preemptive strike. 4. Let's see, around 4. Sorry, 1, 2, 3, 4, 5. Using gold and silver as money with third parties is very difficult at this point because most third parties are still under the misconception that Federal Reserve notes are worth something. You would have to wait until the U.S. economy collapsed, at which time you could use your commerce to conquer by buying up property for a fraction of the cost in gold. Even so, when you do so, you are technically acting as a merchant and you are no longer sovereign. Even if the gold is pre-1933 lightly circulated coin or the silver is pre-1965 90% junk monetary silver, the sovereign is whoever minted the coin, which would be the United States of America in this case. And 6, if you truly understand trust law as it pertains to sovereigns and merchants, contract law, national security law, and negotiable instruments law, as well as the laws of power relating to sovereigns and other heads of state, you will quickly realize that the people's sovereignty never truly existed. What's more, times have changed even more since the idea was first entertained. Our times now make sovereignty a disadvantage in commerce because the moment any sovereign sets foot into the rest of the world to get things done, unless you do business by the barrel of a gun or barter using no currency or coin at all, you automatically give up whatever sovereignty you had by acting as a merchant. This includes use of a license, social security number, registration of an automobile or a weapon, etc. All right, so that's sovereign in Carlton Weiss's opinion. Let's continue on to secured parties. He says, secured parties, nobody's creditor. A UCC financing statement, a UCC1, is a very mighty financial instrument indeed, but only when used for the right situation. Filing a lien on a trust you did not create and did not act as trustee for is inherently fraudulent because you're demanding a debt from an entity that owes you nothing. If the U.S. government decided to issue you a social security number and thereby create a revocable living trust, naming you the beneficiary, you have no grounds to file a lien on that trust. No commercial gain was had at your expense, even if the trust is identified based on the name of the Secured Trust, such as using your name in all capital letters. I can create 1,000 trusts, naming all of them based on the Secured Trust, and the beneficiaries don't even have to be told they are beneficiaries for the trust to be legally and lawfully enforceable. It happens all the time. People discover they inherited an estate from a distant relative, and as long as they accept the benefit when it comes time to distribute the trust does what it was created to do. Beneficiaries are merely there to benefit, not to decide. Beneficiaries don't need to be trusted by anyone to do anything because regardless of what they do, by virtue of the graciousness of the settlor or grantor, they stand only to benefit from the decisions of the people put in control of the trust, the trustees. Therefore, one who is a beneficiary, one who benefits from a trust created by the U.S. government, has no recourse to file a lien when he discovers he's been made the beneficiary of a trust identified based on his name. There is not even a copyright violation because generally, names alone are not intellectual property. The substance represented by the name is the substance represented by the name is the intellectual property. A registered mark cannot be infringed upon in name alone, but the substance connected to the mark must also somehow be subjected to the infringement. I can call anything, as long as the substance is original, which is why you have many different books by the same title. To approach the commercial aspects of the creditor-debtor relationship, for instance, with the 1099 original issue discount, a 1099 OID, without understanding the pivotal role trust law plays in all this is useless. Let me read that again. To approach the commercial aspects of the creditor-debtor relationship, for instance, with a 1099 OID, without understanding the pivotal role trust law plays in all this is useless. There is no room for a UCC1 or even a 1099 OID. The simplest way to say it is that these are inadequate to fix the problem. A resignation, discharge of duty, disclaimer, or rejection of beneficial interest are the only tools you need to remedy any issue relating to holding an unwanted position in a trust. Let me read that again. Carlton has this in bold. A resignation, discharge of duty, disclaimer, or rejection of beneficial interest are the only tools you need to remedy any issue relating to holding an unwanted position in a trust. If you don't want the duty, then resign. If you don't want the benefit, then reject it. Filing to become a secured party creditor, besides being fraudulent, is actually accepting a benefit. The benefit associated with the Secretary of State publishing your commercial recording. All right, so that was Carlton's description and take on secured party creditor, and now he gets on to trustees in commerce. And he says, trustee in commerce, body armor for commercial warfare. Now, take all that and place a simple barrier between the sovereign or secured party and commerce. The barrier is called an express trust under the common law. Throw out the fragile sovereign crown and give the man a bulletproof trustee helmet. Now, instead of him owning a plot of land with a castle, having a royal army and a royal staff of workers, stockpiling his own weapons, having Federal Reserve notes or minted coins in his personal possession, and understanding all applicable bodies of law to protect himself, he now does these things on behalf of a trust. Problem solved. He needs to eat, but how does he buy directly? But does he buy directly from the store with his own Federal Reserve notes or silver dimes? No. He buys on behalf of the trust and works out a private contract with the trust that enables him to eat the trust food and offset his trustee compensation the trust owes him for carrying out his daily duties. He sees an advantage to owning a ranch in a certain jurisdiction. But does he make an offer to purchase in his own name and thereby acquire personal ownership of the property? No. He draws up an offer to purchase or an offer to buy if the trust has the gold on hand. The trust acquires the property and the beneficiaries of that trust benefit from his wise decision. He could then contract privately with the trust as to how he may use the property, offsetting his compensation, if that use involves anything outside of his duties as trustee. Even so, there are ways to keep things strictly within trusteeship if you are really serious about living a trustee's life. Let's say he needs to travel to the state to do the deal. Does he get behind the wheel of his motor vehicle with license in hand as though he's about to transport goods or passengers like any quote-unquote driver would? No, he's a trustee. So he gets into a trust-owned automobile with a certified copy of the manufacturer's certificate of origin and bill of sale and his trustee identification, and he travels to that state on official trust business. Whatever contract he works out with the trust regarding offsetting things along the way with his trustee compensation is a private contract that actually is protected under Article 1, Section 10. There are no questions as to the validity of such a blatant trust relationship. Who's asking? Another trust? The Constitution for the United States of America creates an express trust under the common law, as did the Articles of Confederation to act as a limited governing entity. All right, so I'm going to stop there for a moment, and I just wanted to clarify that for you guys. For those of you who have not been able to pick up on that yet, the states themselves, the United States of America, the constitutions of these two entities, the United States of America and the states themselves, are express trusts. So they are express trusts under the common law. Why is that the case? How did that happen? How is it possible? Because it took two natural people, two real human beings, if you will, at least two, but it took the maybe the 56 men who signed the Constitution, right? It took men to create this contract, this trust under the common law, because there was no statutory entity to authorize this. These were common law rights that they knew that they had, and they created a trust for the benefit of the beneficiaries, the citizens, the state citizens, and the American citizens. All right, so that's why when he was speaking earlier, he said, who's asking? Another trust. So if you're traveling in your trust-owned automobile with your trusteeship documents, any state government officials who are asking about your authority to do such a thing really have no more footing in contract law than you do. You are as equally able to create this trust as the original founding fathers did the Constitution. So Article 1, Section 10 protects this right of your obligations of trusteeship, and that's why you're protected. So let's go on. Article 4, Section 2 provides a clear protection to the trustees of such trusts to do business on behalf of the trust while not being subjected to foreign business entity laws. The protection is real. If the host state tried to stop you, excuse me, my phone keeps on going off. If the host state tried to stop you, the trust could actually sue, and the state would likely settle out of court. Let me read that again. The protection is real. If the host state tried to stop you, the trust could actually sue, and the state would likely settle out of court. The state constitutions do the same for each individual territory. Therefore, the United States Corporation and all of its doing business as and state corporations are, in essence, nominee trusts created under international law by the original express trusts that were created back at the moment each constitution was ratified. Anytime one of these entities has questions for an express trust under the common law, they are asking an equal to show deference not legally required. I'm going to say it again, you guys. This is something that we discovered years ago, I believe even before we came across Carlton Weiss. And so The fact that many of us have come across this understanding, this overstanding, and then had to have Carlton Weiss speak it identically is in our minds a wonderful thing. So let's read it again. Anytime one of these entities, meaning the state corporations, the United States Corporation, anytime one of these entities has questions for an express trust under the common law, they are asking an equal to show deference not legally required. Article 1, Section 10 and Article 4, Section 2 can therefore be invoked anytime one of these entities looks as though it might impair the obligations you have to the trust or block your ability to administer trust affairs in a certain state as trustee. There is no need to run or hide like you would with a pure trust or a federal contract trust. There is no fear of even being prosecuted. How many constitutional courts do you see these days? ? It takes someone like you to invoke constitutional jurisdiction. Now that is power. I'm going to read that again, you guys. There is no fear of even being prosecuted. And he asks very clearly and plainly, how many constitutional courts do you see these days? They can't prosecute you because there's no constitutional courts these days. And it would require you, someone who has a constitutional right and the status of a free man, right? If you recall what we had mentioned in the first reading of the Concise Trustee Handbook, you can come in as a trustee under the protections of as a state citizen outside the scope of the 14th Amendment. So you're coming in under the original constitutional rights as a man. And as he points out in that other in the trustee handbook, that it is not until a trustee accepts the positionship of trusteeship, of trustee position, that he actually becomes a person, but only in the sense of a private contract person. It's not one that took authority or took any kind of franchise or privilege from any outside authorities. So even though you're coming in as a quote unquote person, meaning you have the status of a trustee, it is the trust itself that is the legal entity. And even that, again, as long as you're able to maintain a separation and not incur minimum context, then your protections are incredible. And I hope you're seeing this, you guys. I'm going to read it one more time. There is no fear of even being prosecuted. How many constitutional courts do you see these days? It takes someone like you to invoke constitutional jurisdiction. Now that is power. The extent of the protection may not have dawned on you yet, so allow me to point out that your obligations to the trust are as extensive as everything you do in your daily life. Right. A trustee in commerce eats, drinks, and sleeps wearing his trustee helmet. His clothes, his toothbrush, and even his trousers are trust property. When he has Federal Reserve notes or ameros, they are in the trust's possession by virtue of his trusteeship, never in his personal possession. It's a lot simpler than some would expect. A simple document binder to hold your trustee identification, authorization papers, the trust's debit cards, and the Federal Reserve notes is all that is ever in your possession. Remember, possession is 9/10 of the law, but at the same time, it is only 9/10. There is 1/10 remaining for situations such as this. So you guys have heard that a million times before. Possession is 9/10 of the law. And as Carlton points out, that other 1/10 is exactly for these situations where you are not liable, even despite the fact that you have it in your control. It is not possessed by you. The document binder has the trust's name and a private property notice embroidered on the outside to designate ownership. The notice also names the trustee authorized to have the document binder in his possession. At that point, everything within the document binder belongs to the trust and may be in your possession as trustee. However, the contents are in the trust's possession to the extent of 9/10 of the law. They are in your personal possession only 1/10 by virtue of physically being on you. You are absolved of any liability associated with having the debit card or even worse, Federal Reserve notes. So, comma, for all intents and purposes, you have not reduced yourself to a merchant. And he says, I can go on and on like this, but I am merely trying to illustrate a point. What good is it to be the sovereign or a secured party creditor when your status is practically useless in everyday commerce? Not to mention, how well do you sleep knowing that the game isn't over until the king is checkmate? How many quote-unquote sovereigns are backed into a corner by the federal or state governments every year? On the other hand, the trustee sleeps well every night because he literally can't give up what he doesn't have and doesn't need to. He owns nothing, yet he controls it all. Sound like a familiar quote right there, you guys? I think it was Rockefeller maybe who said that. Own nothing and control everything. This is exactly what they were talking about, you guys. If you haven't grasped that yet, this is exactly what these former businessmen and financial gurus, if you want to call them elite, that's fine. But I'm not speaking about it in the sense of a negative thing right now. I'm saying just because they may have been aware of these things doesn't mean that you cannot become aware of these things. So trust law is the most well-settled law in America. It's the most well-settled law in America. In fact, it is the foundation of our government. Okay? So for you to learn these concepts and to understand why to own nothing and control everything through a trust, hopefully this article gave you some insights. Let's continue on. As long as you maintain a strict separation in this manner, paying close attention to the nuances in possession, you will avoid commingling of trust property and you will never diminish the protection. The commercial environment you are confronted with is as hostile towards sovereigns today as the American Republic always was towards poor whites and free Negroes. They were without legally enforceable rights. They had no protections. What they couldn't do for themselves would not get done, and there was no universal sense of justice towards them. As a result, they were easily conquered over time and became today's shining examples of 14th Amendment citizens, beneficiaries in mind and spirit. They became the exact opposite of today's shining examples of trustees in commerce because benefits accepted equal jurisdiction, even if the man accepting them happens to be an internationally recognized sovereign. However, whose jurisdiction are you under if you don't accept any benefits? Can you see why trustees in commerce are in a league of their own? Question mark. End of article. All right, you guys. So that is the article, our little video for today. We're going to continue making our series for the reading of Carlton Weiss's Concise Trustee Handbook, but we thought you guys would really enjoy this and figured that to be able to give you guys this article before we continue on with our reading of the handbook might make a lot more sense of why you'd be even getting into things like this. So anyway, that's it for today, you guys. Keep strong, keep vigilant on your rights, and keep loving one another, keep supporting one another, give thanks for another day, give thanks for all your blessings, and we'll see you soon. One love. Peace, you guys.